thank you all for coming. I'm Rami Khoury, director of the Issam Fares Institute. I just want to welcome you, and I want to turn over the mic to Dr. Karim Mahdisi, who is our recently appointed Associate Director at IFI, and he will be handling, among other things, the international relations side of the Institute and other things, and he will tell you a little bit about what we're planning to do and introduce our speaker, Dr. Azzam.
Thank you, Rami. Welcome, everybody. We're extremely pleased to have today, this afternoon, Mr. Fateh Azzam, who I've known for a little while now and who I respect very much. Can you hear me? And this is part of this larger program that we have both at the Issam Fares Institute for Public Policy and International Affairs. We're developing a program on the UN in the Arab region. And we've already had a couple of talks, a couple of lectures related to the UN in the region. And we are developing this further. And as this develops, we will keep all of you posted. I think you'll be able to sign up for the newsletters from the Issam Fares Institute. Mr. Fateh Azzam was the Middle East regional representative of the Office of the High Commissioner for Human Rights since 2006. He was the director of the Forced Migration and Refugee Studies program at AUC, the American University in Cairo, before that, so that's between 2003 and 2006. He's a lawyer, and he holds an LLM in international human rights law, and he's been very active in Palestinian and Arab human rights movements since the mid-1980s. And he's, of course, published numerous studies, numerous monographs on human rights law, the right to development, and Arab constitutional protection of civil rights. And he's very well known to those of us both in Lebanon and to those that are following the refugee and humanitarian rights laws in this region. And we're very, very pleased to have Fateh Azzam, the title of his talk will be the Palestinian Refugee Rights, Law, Politics, and Common Sense. I think we'll talk for around half an hour or so, and then we will entertain some questions and answers. Thank you. Please join me in welcoming Mr. Azzam.
Thank you very much, Karim. After an introduction like that, and you must leave here believing every single word I say, not disagreeing with anything I can say with such an introduction. Thank you very much. I thought a bit about, after Ravi and I had discussed my coming and talking about what should I address. And we have spoken a great deal on Palestinian rights in various forums. There's been a number of discussions and forums, Palestinian refugee rights in particular. I know that some Paris is involved in a lot of that. So, what can I contribute to this? So I thought what I would do is wax a bit philosophical on this issue, and that's why I chose the topic law, politics, and common sense. What I'd like to do is maybe propose a kind of a thesis or an idea, and I don't think it's a very brilliant idea or a new idea, that in fact, what is international law? International law is basically an outcome of political agreements. And therefore, it is only common sense that long-term achievement of political solutions, such as peace and security, international peace and security, for example, requires that politics should be informed by law. If law is an output of political agreements, then the process of arriving at those agreements means some considerations have taken place. So, in fact, the reverse then becomes also true, that politics should be informed by law and not only be defining the law. In doing so, I'll be referring to the refugee rights regime in general, but also in particular to the Palestinian refugee rights, and with a couple of examples to make that thesis stick, if you will, and also to allow you a chance to poke holes in it, so that what I hope to do is kind of stir up things to think about rather than make any final determinations about anything. I can assure you I won't use any legalese. I won't be making references to article this and convention that or anything like this, but rather keep my talk to the broad discussion of principles and directions. Generally, when we think about political issues or rights issues, we think them in separate terms, that somehow the world of politics is somewhat apart from the world of law. in fact they're not at all. They're very intricately intertwined. But they've always had a rather uneasy relationship. Politicians get together and make law, then they spend a lot of time trying not to implement it, or finding ways around it. And that's, that's why I thought, okay, let's bring it back and see what we can talk about in that regard. Okay. What is international law, in fact? What are the sources? What makes international law? What makes it is, in fact, a couple of sources. As most of you who have taken public international law will learn that it is in large part the practice of states, what states do. Some of that practice gets codified into laws and conventions, whatever. And some of it is not codified, but is known and accepted as customary international law. It's custom, this is what is done. International law is the law between states. It doesn't necessarily apply to individuals. I say necessarily because, in fact, it is my view and the view of many others that international law that human rights law has actually made that bridge between international protection of individuals' rights, and that it's no longer just a matter of a law between states, although that is still the base. So the practice of states is one of the main sources of international law, but also the series of treaties and conventions that states come together to agree upon is another major source. So we have, practice and custom and implementation. We have also this very specific treaties and convention that they sign on to. Both, I should say, are a result of politics. Both are a result of political agreement. When states come together and negotiate, for example, the International Covenant on Civil and Political Rights, it is a political negotiation. They take into consideration their state interests. They take into consideration power relationships. They agree on certain commonly accepted standards as I might even call it at times, depending of course on the treaty and the situation, the lowest common denominator of what we can agree upon, not necessarily the highest standard we can all hope to achieve. So they are fundamentally political agreements, their treaties and conventions. They are also based on the idea of reciprocity. International law is still very much based on the idea of state sovereignty. Since it's a law between states, so therefore the states are sovereign, they decide what is acceptable and what is not acceptable for themselves. So therefore, in making a relationship with another state, the principle of reciprocity figures quite high. But some of the treaties and conventions are not only based on a negotiation of interests and reciprocity, they're also based on lessons learned from experiences, from past practices, from major issues. And I'll give you an example of those three elements. When you think about international humanitarian law, for example, which is the law, which is sometimes called the law of armed conflict, international humanitarian law began to develop basically in the 19th century, although it had antecedents before that. Principles of chivalry, for example, how people fight back in the Middle Ages were beginnings of some form of regulating armed conflict. But in the mid-19th century, this body of humanitarian law began to slowly develop. And it was based entirely on the principle of reciprocity. So there were agreements on exchanges of prisoners, for example, on munitions to be used, or munitions that are not allowed to be used, way around the turn of the century. One of the most important treaties that came out of that was the Hague Convention of 1907, for example, with a number of appended regulations that actually discuss not only conduct of war, but even of occupation. But all of that body of law was based on the principle of reciprocity. Then what happened is World War I and World War II. And the atrocities and the level of destruction that was wrought by these two wars hastened the process of articulating humanitarian law. We end up in the Geneva Conventions of 1949, 4 conventions that deal with civilians and prisoners and wounded, etc. And those particular conventions are not based on the principle of reciprocity anymore. They're based on moral principles, that civilians should not be targeted. And it's not a question of targeting your civilians or targeting my civilians. by the very fact that the Geneva Conventions developed a set of violations that are called grave breaches that say, anybody who is committing grave breaches that are tantamount to war crimes or crimes against humanity can be tried by any state under universal jurisdiction, even a state that had nothing to do with the conflict. So that was a very important development that also led to the development of human rights law as well. So here you have an example of lessons learned, horrors learned, political agreements made to say that we shouldn't really be doing this anymore. We should not be targeting civilians. We should not be bombing cities, etc. In other words, why do we have law? Because states politically agree on modes of behavior designed to benefit individual states and the international community as a whole to organize their long-term peace and security and relationships in a manner that reduces conflict and while cognizant of power balances and economic interests. So this is already in the negotiating process. These are the balances arrived at. Now, each of us might sit outside of that negotiating process and say, well, they should have done this, or they could have done that, or it would have been better if they had not included this provision, for example. But in the end, we're not the states, they are. And the political agreements that they arrived at to achieve this convention, whether it's the Geneva Conventions or the International Covenant on Economic, Social, and Cultural Rights, for example, what I'm saying is that it's their political prerogatives and the motivations that arrived at this set of standards. It's not a perfect science, of course, and there's a lot that we can criticize, especially when it comes to the area of implementation of law. But it is what we have, and it is constantly developing. So in other words, it is also changing. It is not cast in stone. Once you have a text of a law, it has a presence. It has a, it needs to be made to live. But it can also change. So there is a possibility also of changing. Now, politics has been variously called the art of the possible, or the art of compromise, or various other expressions. Or it's simply viewed as a battle of power and interests. States as battle power and interest. Now, it's through these arts, the art of possible, compromise, through these battles, that legal agreements are made and political balances and compromises are already contained within those legal agreements. This is the most crucial issue I want to be clear about, that within the treaties made, the interplay of interests, of power, of politics are already taken account of. To give you an example, when we talk about freedom of expression as a guarantee in the International Covenant on Civil and Political Rights, it's not, states did not agree that this was an absolute right. It is a right that is moderated by respect for others' rights, others' reputation, or even public order. How you interpret that and how you explain that within each context and each political environment may be different. But that was what states' political discussions arrived at as a definition of freedom of expression. So therefore, it's only common sense, in fact, to consider that good politics are politics that build on this long-term vision that was articulated in the balances and agreements made politically through articulating Treaty X, for example. In other words, if you have said that my long-term vision in discussing a particular issue, such as refugee, is 1, 2, 3, then it's only good politics to say that my future politics has also based on 1, 2, 3 that I've already agreed to, because that has already taken into account the different discussions. This is the key point. So, how can we put that in the context of refugee rights, for example? Let's go down to the area generally of refugee rights and see how that fits, where this kind of thesis works. People become refugees when they're forced by conflict or persecution to cross borders, to cross an international boundary in particular, and when they lose the protection of their own state. So they seek international protection across the border. international protection, either in the form of the state that hosts them initially, but it also becomes an international responsibility, not only the responsibility of the host state. So they must rely on such protection, starting with the host state. Now, international law, as agreed upon, views refugee status as a temporary. It does not look at refugee status as a permanent state of affairs. The idea is that there's conflict or there's persecution, people become refugees, they have to be taken care of in certain ways for a certain period of time, but at some point they have to, their situation has to be resolved. They cannot be refugees forever. So solutions offered, and I think we heard Karen Jose a couple of weeks ago say a similar thing, are voluntary repatriation in safety and in dignity. This is one of the first, most preferred solution for refugees, or ending refugee status. Voluntary integration or voluntary resettlement in a third country. Now, integration and resettlement are understood as, resettlement is understood as basically you go, you resettle in another country, you acquire the citizenship of that country, you become a citizen, and your refugee status is ended. You now have a state of which you are a citizen, which provides the protection that's needed. Integration doesn't necessarily mean that. It can mean that you can integrate in your host state, you can become a citizen, in which case you are actually resettled in that host state. Or it could mean, economic, social, cultural, whatever other integration. In other words, you can be part of the fabric of society, but without necessarily acquiring the full rights of citizenship. Now, with all of those three solutions, repatriation, integration, or resettlement, the most important element is voluntary. Refugees have to voluntarily be willing to return in safety and dignity. They have to voluntarily be resettled. You cannot force them to resettle in another country. Now, as I said, this is a temporary state of affairs until one of those three solutions can be achieved. And here I'm talking about the general refugee rights regime. Until these are achieved, there are, in the temporary state, a set of rights that are articulated, generally in the 1951 Convention on the Status of Refugees, the 1951 Geneva Convention on the Status of Refugees, but also by human rights treaties and conventions. In other words, what rights can I enjoy as a refugee in a host country, of which I'm not a citizen, while waiting for my permanent solution to arise, or to be able to exercise. I should enjoy a set of rights that are defined by the Geneva Convention and by human rights law generally. Some of those rights are absolute, they are active, they're actionable immediately, nothing is required for them. And these are what we call in human rights law non-derogable rights, inalienable rights, if you will. For example, freedom of religion. There's no justification whatsoever for anyone telling you to worship or not to worship. But freedom of religion is one. Non-discrimination, freedom from discrimination is another. That's become now a customary norm of international law. Freedom from torture, for example. To have a legal personality, to actually have a legal presence, and have a legal personality that enables you to either go to courts or to achieve certain things or to be able to do. The entire world now is based on what is your legal personality, what is your setup in law. So that is also one of the rights. And there are also other rights that are to be enjoyed by refugees equally with citizens, although they may not be necessarily inalienable as such. The right to assistance, the right to culture, a number of other things. Some rights in the refugee regime, there's kind of a gradation of rights, which is very interesting, and there are some scholars that explain it. I'm going to mention just a little bit of it without going into too much detail. As I said, some rights are inalienable, regardless. Some rights you can enjoy equally with citizens. some rights you can enjoy an equal status with any alien in the country or any foreigner in the country. In other words, the fact that you're a refugee should not exclude you from rights that are given to any other guest worker, for example, or to visiting tourists in the country. Right? So there's that kind of a level. And there's also, of course, the level of what they call in the convention, preferred nation status, which means it's a step even above any alien in the country. You have a preferred nation status. Some countries don't require visas, for example. Some countries say that you can work in syndicates, whereas other countries say no, you have to have reciprocity to work in syndicates. We know that's the case in Lebanon, etc. So you have different levels of rights, and you get into a lot more detail about what refugees can enjoy in the country. Now, some experts, like James Hathaway, for example, has been arguing, and I think convincingly, but I don't think it's been totally made its way into the full understanding of the rights regime, that the longer a refugee stays in the country, the more rights should accrue to that refugee. So in other words, if I'm here only for 3 months, my basic needs might be all about tent and shelter and food. But if I'm here for 3 years, I have to start talking about the right to work. I have to start talking about the right to health. If I'm here for 5, 6, 7, 10 years, I have to start talking about Social Security. I have to start talking about my old age. I have to start talking about other elements of human dignity that must accrue to me. Not because I'm special, but because I'm human, like any other person in that country. I mean, that's at least what the argument is. Now, in any event, human rights law, here, because I have been talking about refugee law in general, right? Human rights law, to which states do commit themselves voluntarily by signature, by ratification, does fill in any gaps left in the rights in the refugee rights regime. Now, if you think of it historically, the Convention on the Status of Refugees was adopted in 1951, and states can sign on to it and become party, etc. The International Covenants on Civil and Political Rights and on Economic, Social, and Cultural Rights were arrived at in 1966. So you're talking about a number of years later, where states have had a chance to recover better from World War II and from the horrors of that experience, and have begun to actually think more in long term and have to think more in stability terms, or in terms of stability. It was also during the Cold War. That's all our discussion about the two covenants, being economic, social, and cultural on the one hand, and civil and political on the other. Now again, as I said before, refugee law and human rights law. Refugee law is designed to think of the status of refugees as temporary. But what happens when it's not? What happens when those rights are not respected or protected or fulfilled? Like for example, the Palestinian refugee problem that has existed for 60 years. Can refugee law generally, or even UNRWA's mandate, or even international law in general, is it sufficient to consider the temporary 60-year presence of Palestinian refugees in any of the countries where they are? There are states who were conscious when they were negotiating of several factors that actually thought it's problematic. One is that hosting refugees is, in fact, a burden on host countries. Whether or not they are paying the money, or they are accepting, or they're partaking in infrastructure issues, there's a whole host of issues that have to do with states hosting refugees. When they were negotiating the convention, they're saying, well, there has to be international cooperation. Any host state cannot assume the full burden of hosting refugees, particularly when you start talking about hundreds of thousands and millions of refugees. Within refugee communities, a life without dignity would lead to anger, frustration, destabilization, and consequently probably an increased potential for ongoing conflict. So really, if I undertake negotiating the Refugee Convention, for example, or even negotiating refugee law and human rights law, you say, okay, if I don't guarantee basic human dignity rights to those refugees, I'm creating conditions and situations, a situation where there is increasing frustration, doors are closed, there's no horizons for the future, youth are not being educated, there are no work opportunities, there could be a rise in drug use, it could be a rise in crime, it could spill over into the other communities, not just the refugee community. You start imagining, and as we know, as research actually has shown, that in fact this is the case. If you do not enjoy the basic rights that people, a life of dignity, then these problems will start to occur. More recently, of course, it has also become a commonplace assumption that dispossession, closed opportunities, and failure of solutions can also lead to violent reaction and also terrorism, as we know. Now, we find examples in every refugee situation, including the Palestinians, but here I want to point to the preamble, the introductory sentences to the Universal Declaration of Human Rights, which basically states out why did the international community come together and adopt this Universal Declaration of Human Rights. One of the reasons was, and I can't quote exactly, maybe Eleanor can help me, but I can't remember the exact words, but it's to the effect that in order for people not to have to resort to rebellion against tyranny, human rights must be protected by law. And this is basically the concept that really comes behind a lot of what I'm trying to say. So, if it's common sense to say that implementing what states have already agreed to in the various conventions and treaties makes good politics, then the laws themselves consider longer-term purposes and consider the implications of not doing so. See what I'm trying to say is that if we have established, and of course you agree that I have established, or I've established, that treaties that protect rights are a result of political negotiation, then it only makes sense to say that the purposes of this political negotiation that resulted in this treaty must also always be kept in mind in making new politics. And that could be the defining difference between good politics and bad politics. There is such a thing. The good politics that builds on the lessons learned of the past and tries to create conditions for solutions in the future, or the bad politics that ignores the law that was agreed to and begins to repeat the same mistakes and repeat the same problems of the past. A very good example, of course, is the issue of Palestinian refugees, as I began to say. It's very easy to agree, it seems to me, that the international community has not pursued good politics with regards to the Palestinian refugees, by the fact that the problem continues and the crisis continues and has continued for 60 years, by the fact that at least 7 major cross-border conflicts have taken place since then, at least 7 major ones, and countless other less than major ones, but very serious ones that have resulted in a lot of destabilization, a lot of death and destruction, etc., between host states and within host states and within the Palestinian refugee camps themselves. And a lot of that is the result of the implementation of bad politics, basically. We can even go to the Oslo process, which relegated the discussion of solutions to the Palestinian refugee problem to what's called final status negotiations. Originally to take place 5 years after the signing of Oslo in 1993, it's now been 15. It's now been 15 years. And we see what's happening in the camps, not only in Lebanon, but also in occupied territories, continuing to express that failure as well. So it's useful to review a little bit some of the rights that should form a basis for solutions, and to consider, okay, what level of enjoyment is there now of those rights. To begin with, of course, the right of return. Now, the right of return is an expression, or one of the clearest expressions, of voluntary repatriation, if you will, in safety and in dignity. But here I want to make what I think is an important point that most discussants, particularly Palestinians, miss. This is that the right of return was not provided by General Assembly Resolution 194 at all. The right of return is closer to a customary law principle of international law than it is to an agreement by states that Palestinians now have the right of return by virtue of General Assembly 194. If anything, General Assembly 194 diminished the right of return because it conditioned it on Palestinians who wish to return and live at peace with their neighbors. So, in my view, that provision, I think Article 11 of General Assembly 194, in fact, is a violation of the right of return. So we should actually, those who believe in international law and the principles of international law, should say that the right of return is a sacrosanct international customary law principle. I'll remind you of the Universal Declaration of Human Rights, which most people now will agree has entered the aura of customary international law. And the article, I forget the number of the article, that says everyone has the right to leave one's country and return to it. Period. That's simple. No caveats, no derogations, no ifs, ands, and buts. It's very clear. So the right of return is, I think the Palestinians themselves have done themselves a lot of disservice by continuing to rely on General Assembly Resolution 194. Proposed ideas and solutions on Palestinian refugees were rarely based on the right of return, but rather they were relegated either to negotiations of numbers and modalities. And, Israel will take 70,000 and then, etc. But it was never a matter in the actual negotiations between states, never a matter of principle, never a matter of law, but rather to negotiate backwards what international law has already agreed upon. Another one, of course, is the right to self-determination. Now, we often think about the right to self-determination as a political right. It is in large part. It did come out to begin with in the post-colonial period, where say all peoples have a right to self-determination, meaning nobody should be colonized by any other entity, etc. But I would even take the right to self-determination a little bit further and say actually individuals also have a right to self-determination. I would even say that, as an individual, human rights law, the body of human rights law has said that I should be able to decide if I want to be beaten up on the street or not. That I should be free from coercion of any kind. I should be free to worship, I should be free to speak. I have to respect others, but I should be free to determine my own destiny as an individual. And in fact, I would even make the argument that the collection of our individuals, of free individuals that can be self-determined, are the only ones capable of achieving the right to self-determination. You can make that kind of connection, so that, I think that's it. It was recognized in human rights law very specifically, the right to self-determination. You will find it as a common article in both the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. At the very beginning of the covenants, people have the right to self-determination within which they find their own fulfillment, individual, and exercise their full rights, etc. Again, I don't remember the wording, but if you look it up, it's there. So, in other words, the very base, and sometimes in human rights circles we refer to the right to self-determination as the parent right of all rights, all human rights. And that makes the connection between what I was trying to say about individual self-determination and collective self-determination in a political sense. Of course, the right to self-determination doesn't necessarily always mean statehood, as long as there is a free determination by the collectivity what kind of entity we have. And there have been instances in history where people have voted to become part of the bigger state or part of something else. That's another matter. Of course, there's also, after those two fundamental rights, the right of return, right of self-determination, you've got the whole series of fundamental human rights at all levels that I mentioned before, covered in refugee law and in human rights law in all of its manifestations, treaties, and conventions, what have you. But these are enjoyed, of course, differently in different countries, wherever Palestinian refugees are. In occupied Palestinian territories, for example, Palestinian refugees are treated equally with those who are not refugees. Palestinians who already still live in their original lands and homes, in the West Bank and in Gaza, for example. They, of course, constitute quite a large proportion of that population, the refugee population, and the non-refugee Palestinian population. They're treated equally by the occupation. Meaning they both have residency rights. They are both, they can both be arrested, they can both be allowed in or out. They are equally subject to the same kind of restrictions. It's difficult to talk about the level of rights enjoyment by Palestinian refugees in the OPGs because that applies to everybody in the occupied Palestinian territory. The non-implementation of law at any level, we already see the results of it in the ongoing occupation, in the treatment of the occupier, and in the frustrations and everything from the rockets to the suicide bombings to everything. The result of, again, what I was saying in the beginning, the thesis that bad politics is politics that does not learn from previous lessons, and if we can say that previous lessons are articulated in law, this is the idea. We have a very different situation in Jordan, where Palestinians are actually citizens, as you know. Actually, most of them, not all of them. There's about 100,000 Palestinians from Gaza in Jordan who are not citizens, and they have, have a different set of rights than the Palestinians who are citizens in Jordan. Jordan gave citizenship to the Palestinian refugees from the West Bank primarily. They have equal economic, social, and cultural rights, as well as civil and political rights, with Jordanian citizens being citizens themselves. Now, of course, we do hear periodically, we are aware of certain accusations that occasionally surface with respect to discriminatory practices in the Kingdom of Jordan, and a number of issues come up. Things are not, it's not necessarily a completely easy relationship, but at least at the level of rights, one can claim that Palestinian refugees who are citizens of Jordan enjoy a life of dignity in Jordan. Now, the question there becomes then, do they actually enjoy political rights in the full sense of the word? Now, as citizens, they vote, etc. There may be issues and discussions, and I don't want to get into too much of that, about their access to being elected. And things have, historically things have shifted. There have been prime ministers, and there have been, so things have shifted over time, and those who follow the politics have better memory on that than I do. When things were tense, 1970, big conflict, Palestinian resistance was driven out. That was tense because of the clash of politics. Right? So that's a whole other story. We can discuss it. In Syria, the situation is also a little bit different. Syria gives the Palestinian refugees their rights equal to citizens, equal to nationals, with the exception of political rights, meaning they don't get citizenship, which means they cannot be part of the political scenery of Syria, except independently and under certain conditions. Right? So we cannot say that generally political rights are enjoyed by Palestinian refugees in Syria, but they do enjoy economic, social, cultural, and civil rights equally with Syrian nationals. In Lebanon, the situation is probably one of the most difficult, because it's very complicated, with much history behind it, including, of course, the participation of Palestinians in the civil war and what has followed from that. But in terms of rights, there are actually few rights that Palestinian refugees can enjoy. There are severe limitations on the right to work, and actually reversals of policies over time that had been better and now been made much worse, including, for example, the issue of ownership of property now with the ban, including even at times also freedom of movement. I'm not talking about during the Civil War, but other times restrictions on rebuilding, and there's a whole host of issues. The Palestinian refugees in Lebanon, comparative to the other Palestinian refugees elsewhere, probably have the hardest time in terms of enjoying basic rights of human dignity, if you will. In fact, in discussions, the rights perspective, other than at times being brought up by human rights organizations, for example, is absent from the discussions. The discussions are not based on a rights discussion. When we're discussing Palestinian refugees in Lebanon, it's based on historic or political, or talk about demographic balances, or we talk about a number of other elements. But not often do you hear people in high political office talk about rights for Palestine. I won't say never, but because I can't hear everybody all the time, but at least from what I've heard, there's very, very little of that. Now the last situation which I mentioned quickly, and I'll be finished, that in Egypt, Iraq, and many other countries, there are very serious problems. Presumably, the Palestinians there are not registered with UNRWA, for example. They don't have a legal presence as they would under UNRWA in the countries where UNRWA operates. They are registered by the government. They're registered with the government as Palestinian and Arab refugees, if you will. And their situation is also very tenuous. And it can go up and down with the political fortunes of what's going on. Under Saddam Hussein, he treated them very well. As soon as he was overthrown, the rest of Iraqi society turned on them and essentially drove quite a few out. There's been some very serious problems. Most of you have seen, heard about since 2003, thousands of them stranded between the Iraqi-Jordanian and the Iraqi-Syrian border. Fortunately, UNHCR has kicked in, has been working very hard, and most of these have now been resettled to other countries like Chile and Brazil and other places, but not in Arab states. Some have actually been absorbed into Jordan and I think Syria as well. I don't have the figures. But that's a problem. And a similar one, for example, in Libya, when Gaddafi decided he was going to after Oslo, send the Palestinians to Palestine, and Egypt wouldn't let them in, so they got stuck on the border for years. And my understanding is that they're still there. But they've actually created other communities. Now here we talk about 15 years stuck in no man's land between countries. There are many, many stories of refugees being stuck in airports or on airplanes where they're going from one country to another. The country won't let them in, so they're sitting there. I think Tom Hanks should have been Palestinian. Airport, terminal. And lastly, in Egypt, the situation is really not significantly better. They have very serious issues. They have to have work permits in order to work. They're very tightly controlled. If they go to school, they pay in sterling pounds. They don't pay, they're not treated like nationals. They're treated as alien students. And that means much higher fees for everything. Registering once a year and paying lots of fees, and you have to renew your residency every year. Lots of complications there. There's been recently a book published by colleague and friend AUB Center on the Palestinians in Egypt, and she was actually doing that research when I was at the University in Cairo, as Karim mentioned. And it's a very valuable book about it. At that time, since then, has a very little known problem about how Palestinians survived in Egypt. Okay, so to finish off, why is it, in my view, common sense to approach Palestinian refugee problems with a much stronger emphasis on law and rights? Because an educated and working refugee community which enjoys at least civil, economic, and social rights can build better relationships with the host state, can pay taxes, and can invigorate the local economy. They can be a community that is a partner community with the host state. if they are able to work, if they are able to send their children to school, if they are able to participate, and that would include in the economic life of the community, and that would include paying taxes, it would include benefiting from services, and that would include contributions to the life of the community. With strong relationships with the host state, refugees can even exercise political rights within their own community, certainly, and they can also become an ally to the host state in regional and international forums. Here you have, a state that treats you like a human being, that respects you and your dignity, that supports you in your efforts, say, for your right of return or for self-determination or whichever, in your international fora is your main thrust, then you can be its ally in regional and international dynamics on a political level. So that's also an important one, not to let go that politically. It's also very important for the host state to treat Palestinian refugees well on the basis of the rights that are supposed to be accrued to them by virtue of human rights law and refugee law. Now, such an empowered refugee community can be a much stronger advocate for the right of return than one which is suppressed, oppressed, and worried about daily survival. That seems to be ABC logic. That if you have an educated refugee community, an educated and working community that is not worried about survival, can actually be a much better advocate for the right of return and for self-determination than otherwise. Now this, of course, depends also on the political and economic environment. It's not so simple, of course. The different competing interests within the host states as between the states at the regional level. As we know, citizens of all of the countries mentioned, I just talked about here, where Palestinian refugees are, also enjoy different levels of human rights themselves. So in a way, it's also tied into the complexity. But the point here is that advocacy for law-based political solutions must inform these political processes, so that politics can become good politics and think in long-term vision based on lessons learned, rather than short-term gains or considerations. So in other words, if politician X does not want to agree to proposal A, because between now and next week that politician is going to be able to do that, that's a very short-term bad politics approach, rather than building on the rights approach and thinks in much more long-term vision than that. It's not so simple approach, but the approach can be taken at least as a starting point. It can provide solid ground to build upon, to continue to develop international law, and also to fill the gaps that still exist. And I would be the first to admit that international law, and I said in the beginning, it is not a perfect science. It is not complete, and probably will never be complete. And there are huge gaps that exist already in international law. These gaps are constantly moving and developing to be filled. One of the most serious gaps is, of course, implementation and enforcement of international law. And at this point, as we know, the international political system cannot be described as democratic. We have the General Assembly and all of the principles of the United Nations Charter that are perfect and excellent and makes for good, solid ground for cooperation. But the executive arm of the United Nations is not a democratic institution. The Security Council is not a democratic institution. There are 5 countries that hold sway. So that's an issue that keeps coming up, and that's a problem in the implementation. I think personally, for example, that the development of human rights law has gone a long way to begin to chip away at this undemocratic attitude by saying that no matter what you are, what country you have, what level of sovereignty you have, if you commit certain crimes, you will be brought before the International Criminal Court. If the decision is a judicial decision, if you allow the decision to be a political decision, then yes, certainly, Omar al-Bashir will be brought before the International Criminal Court, but Ehud Olmert will not, if it's a political decision. So that's where there's a responsibility on the part of civil society, on the part of activists, to continue to push the universal jurisdiction idea, to continue to push the implementation of law idea, not to throw out the baby with the bathwater, not to say, well, you know, the international legal system is selective, because look at Omar al-Bashir and look at the Good Omar, but rather to say, okay, that's a problem of politics. It's not a problem of law. So we have to push the politics to be based itself on law and not the other way around. I think I will stop here and give you the chance to both hold something. Thank you.
Thank you very much, Fateh, for this eloquent. You made a very eloquent case for the rights or law-based solution to promote good politics and to hopefully move away from bad politics. I'd like to open this up to questions, but please identify yourselves before you ask the question, and try to keep your question short so that we can get as many questions as possible. And I'd highly encourage students, if there are students here, I'd very much like to have students ask questions if you can.
Ahmed Moore, I'm just wondering whether you discussed the control of refugee rights or status rather from one generation. Will you discuss the control of refugee status from one generation to the next, particularly in places where full citizenship is enjoyed?
Thank you, Fateh, for your comments. Well, 2 points. The first, when I read the title of your lecture, I was wondering what you mean by common sense, and I thought it will be the moral, because every time we talk about justice, we talk about 3 underpinnings: law, politics, and morality or moral. So apparently you meant more best practice by common sense. So do you think that we can inject the question of morality, and now it's one of the major discussion in the world about human rights, that we cannot legify everything, especially laws, that morality is very important, and we should think about the right of the right people from this angle. The second point quickly, do you think, I am so glad that you raised a question of protracted refugees as a distinctive categories compared to refugees from poor. Do you think that it is time that UNHCR or your office, that you start thinking about a new continent, taking into account only this category, and maybe to invent labels different from protected refugees, and just to show this distinctiveness? Thank you.
Please make sure to identify yourselves for your question.
Hi, my name is Fateh Azzam. I'm the head of the Arab Human Rights Fund here in Beirut. I have 2 questions, very short. One is, when people, if they tell you without cynicism, it's all beautiful with international law and so on, but it brought us nowhere, because we have outside it anarchy, and the rule of the most powerful can enforce whatever he or she wants on the issues of refugees. The second question is, how do you balance the right of refugees to be treated with dignity in the host countries with the fact that the more these people feel comfortable in the host country, the less they will be willing to leave at some point or return to their country, or from which they have been ejected by force. Yeah? No doubt that anybody with the refugees has to have all the rights that you have mentioned. This is not the issue. But how do you balance that? Thank you.
Yeah. Now, the conferral of refugee status from one generation to the next, that's also a matter of legal definition. UNRWA's own mandate as UNRWA for Palestinian refugees talks about Palestinian refugees and their descendants. Resolutions also discuss refugees and their descendants. So that is defined in that fashion. If you are born in a refugee camp, and here we're not talking about Palestinian refugees necessarily, any refugees, born in a refugee camp, they acquired the status of tenants. In fact, that was a problem with Palestinian a bit, but they acquired the status of the tenants. So if the tenants were refugees, say from Sudan, sitting in Egypt, their legal status continues to be that of Sudanese, but then they also are refugees as descendants of those refugees. Now that creates a different problem for length of stay. If the person is a refugee because of conflict, then it is possible that the person could go to the embassy of their country in the host state and say, register my child, for example. But if that person is a refugee because of persecution, it becomes more difficult. So eventually what that happens then is people become de facto stateless persons because they lose their effective link with their home state, and they become in fact stateless persons as well as refugees. So that gets complicated. The problem with UNRWA's conferral of registration, for example, was always the fact that you could only inherit your registration if the father was a refugee. If the mother was a refugee and she marries a non-refugee, say Lebanese citizen or Syrian citizen or something, then her children are not refugees, they're citizens of the father. So then that became, and UNRWA came under quite a good bit of attack for discriminatory practices that women should be able to give refugee status to their children in the same way as women should give nationality to their children. So these are the issues that come up when we talk about conferral of status from one generation to the next. I don't know if it answered your question or if there's anything more that I could say about that. The question of morality is a very interesting one, but it's a difficult one, isn't it? I mean, in the end, can we comfortably say that there is one morality in the world? It's a tough one. Can we say that there is a morality, at least a certain minimum standard of morality we can all agree to? I would say yes, probably. Probably we can find some standards of morality that all cultures and civilizations can agree to. That's the human rights law. Right? So in other words, I find the translation of morality in legal text, because in the end, when states agree that this is a moral thing to do and this is an immoral thing to do, it has to be somehow codified as a text. It has to be an agreement made. Now you and I can sit and talk, over a glass of art or something until morning about all kinds of issues and agree on all kinds of things. The next morning that disappears. It might change us a little bit. It might convince me of certain ideas and vice versa. But in the end, in the international world, you need that to be agreed to in some formal sense for it to become, and you can say that, in fact, human rights law and humanitarian law, one of their main motivations was morality. This is why states said that you don't need reciprocity. It's not a question of, I won't kill your prisoners if you don't kill mine. It's a question of even if, after the Geneva Convention, if I kill your prisoners, you're still not allowed to kill mine. I can be dragged before a war crimes tribunal. But you wouldn't if you don't kill mine. So it's not a question of me and you, it's a question of international morality that found its expression in humanitarian law and in human rights law. This would be how I would look at it. Now, if we can add the morality argument as a supportive argument, that's great. I don't have any problem with that. And that morality can be a religious morality, but it's dangerous because other moralities that are also religious moralities can also be harmful. If you look at the extremism of any religions, whether you're talking about extremist Judaism or extremist Christianity or Zionist Christianity or extremist Islam or any of it, extremist Hinduism and Islam, massacre each other, and that was morality. So it's a tough one. The other question about protracted refugees status, it's a term, basically a descriptive term. It's not a legal term, really, in refugee law. We don't really talk about protracted refugees as a kind of legal definition, but it's a descriptive term. You're talking about, situations that actually defy the normal definitions in the 51 Convention, which has this underlying assumption that within a year, maybe 2 or 6 months, these things will be resolved and that person can be voluntarily repatriated or whatever. So I'm not sure that there is a need for a new convention on protracted refugee situations. I would rather say, hey, let's really bring the full force of international moral law, like human rights law and humanitarian law, to bear on the situation of those refugees. This is the argument that I try to make. Lebanon is committed under at least 7 of the 9 human rights treaties. The last 2 is on the way only because they're new. It hasn't been done. Okay? The Convention on Disabilities and the Convention on Enforced Disappearance. All the other ones, Lebanon is committed. That means it has obligations under those conventions, not to its citizens, to all within its jurisdiction. Now that means that there have to be modalities that define how it discharges that obligation. So that would be, it seems to me, a better way to do that rather than just creating a new convention. Now, Fad, I mean, it's a subjective judgment that anybody would make that all of this discussion of law has gotten us nowhere. I'm not sure I agree. I mean, I would agree that international law is not being implemented properly. I can agree that there are gaps in acceptance of international law by states. I would say even the United States. The United States itself is only party to 3 of the major international organizations. Lebanon is 7. So that doesn't mean we need to throw out the baby with the water. It doesn't mean that the whole edifice of international law that has actually organized a whole set of resolutions since then is useless. It just means there's always a constant tension and dynamic between the bad politics that look at immediate short-term interests and power relationships and the good politics that builds on what law provides, because law is the result of that negotiation that I was talking about earlier. So, I mean, I would only say that, you have to look at the broad view. But I would say to those people who would say, what law? I would say, look at the broad view and don't look only at what is upsetting you with this. This is really the only thing one can say. And it is a dynamic moving process. It's not finished. I suppose there's always a possibility that people get comfortable in the countries and don't want to leave. But that's fine. Who said they have to? I mean, here's the key. Here's the key. If we are talking about law-based, human rights-based solutions, then we're talking about voluntary repatriation, voluntary resettlement, and voluntary integration. Now, the integration may not be possible because the host state refuses it. That means no matter how comfortable you are, the host state will limit your options. It will tell you, no, you can't be a citizen. Sorry. How many people would love to be Canadian citizens? How many people would love to go to Australia and actually do and become citizens? How many of those people actually forget the homeland once they do? Some. All? No, not all. The Jordanian citizens who are Palestinian refugees, have they forgotten the Palestinian issue or the Palestinian cause? I don't think so. I'm a U.S. citizen, and I'm a registered Palestinian refugee as well, right? I can't forget. So, I mean, it's very difficult to make this sweeping kind of the danger of being too comfortable. I think there are many other dynamics. Yes, it does happen. People do get comfortable, but it's not always up to them. That's the problem.
Three more questions.
My name is Corinne Minelli. I'm an assistant professor for international relations and international law here at AUB.
Corinne, can you speak up a little?
Yeah. I would like you to elaborate a little bit more on how you argue that the principle of self-determination should be understood, should be interpreted. Because in practice, we know that this principle has been restricted to a very limited number of cases. So I would like to understand what exactly you mean by the application of this principle of self-determination. Thank you.
Rosemary Sayer. I'd like to ask your opinion of the Arab League as a global movement, which has an influence on the refugee situation in the host countries. And I understand that in 1991, the Casablanca Protocol, which formerly had given quite a lot of rights to the refugees, was revised, and the revisions tended to increase the power of national interests over refugee rights. What kind of pressures do you think would be brought on a body like the Arab League? It seems to me it's sort of inaccessible to the pressures of either Arab public opinion or international human rights community pressures.
My name is Fateh Azzam, and I work for the Norwegian Refugee Council. I would like to know what you would answer to people or actors that claim that the right-based approach to the Western idea, a kind of colonialism, or even how you concept Western ideas. Thank you.
You know, in Arabic we say oftentimes, and I think it's a cultural thing, on the fact that it's saying حقك عني والحق عليك. And this has been, you know, for centuries. And what literally it means, your right is with me. Which means حقك عليك, no? Which means I'm mistaken, you are right. Your right for justification is my duty. That's the fundamental rights concept. You know, where I don't know where people get the idea that it's a foreign notion, or it's a Western notion, or even a colonial notion. The only way that I can see people thinking that is people who would rather have a much more local kind of adjudication, would rather not belong to an international system, would rather bring the world down to their own village or tribal level, where you go to the chief of the tribe and he will solve your problem for you, or you get together with the neighborhood and you solve that. You don't need states, you don't need international law and international anything. It doesn't make sense to me that people would assume that the rights-based approach is a Western notion. I don't understand. I would like perhaps afterwards you can explain to me more what those people mean. It doesn't make sense, honestly. And going backwards then, in terms of Rosemary, the idea about the Arab League, yes, you're right in terms of the Casablanca Protocol, which for those of you who may not know, basically said that Arab states have a responsibility to treat Palestinian refugees equally with their own citizens in the whole walk of life, etc., etc. That was revised in 1991. It's also in Lebanon, for example, the 1965 Cairo agreement that was also abrogated by the Lebanese government. That said similar things as well. The League of Arab States is a funny animal, and I think it's an important institution. We can't discount it. But I think also so far up to now, has not been a terribly helpful institution. Not because they're terribly bad people necessarily, but because one of their main rules is that they cannot actually do anything except by consensus. Good luck. And that's been a very, very serious problem. In the Arab League actually taking any measures or taking any steps, because there was always at least that one or two states to say, well, it's not in my interest to let this go through, or to let this happen. Now, we've been dealing in my office, the UN Human Rights Office, in the region with the Arab League, particularly after the adoption of the new Arab Charter of Human Rights. It was finally passed by the Council of Ministers and put up for ratification, and now there are 10 countries in the region that are Now this is, it was developed in the context of the Arab League processes, but it's an independent process from the Arab League. But the fact that the Arab League put the effort to push it forward, the first document of this sort, an Arab Charter for Human Rights, was put together in the early 70s, or the mid-70s, 76 I think, I can't remember. And not one state signed it. Not until they've started the process of what they call modernizing the Arab Charter, which was a dead letter anyway, and actually came up with this new charter. Now, that has potential for some movement. You get the sense at times from the Arab League of willingness to begin to engage in more activity and more reform. There's a newfound energy kind of thing. And I think that's partly the result of newfound energy in the number of states in the region, heading very slowly, but I think steadily, towards some levels of reform within their own context. And that's finding expression in the general inter-Arab forum of discussion. I wouldn't put a lot of faith in the Arab League as an Arab League to actually move on, to move on the Palestinian rights in general, let's say, or the situation of Palestinians in the region. Because the states members of the League of Arab States are extremely jealous of their sovereignty. So it would be still very difficult for them to let's say, make a decision. Because that's often a mistake we all make, is that somehow, the United Nations or the Arab League or some other forum, intergovernmental forum of that sort, can make a decision that can then commit states. Well, in fact, states are those forums. The members, the 22 members of the Arab League are the board of directors of the Arab League. They're not subject to it. It's quite the other way around. The General Assembly is the parliament of the United Nations, but it's a parliament that doesn't elect 5 of the 15 members of the Security Council. All the other ones do get elected through this terms. The executive authority is the Security Council. But the Security Council, except for those 5 member states, will always express the general will of the parliament, of the members of the General Assembly. So it's an intergovernmental organization, and it's very similar with the Arab League, except at a smaller scale. So, I would pay close attention to the Arab League. I would continue to try, at least from a civil society perspective and even academic perspective, to do studies and to promote the idea that there is a responsibility, a collective responsibility for Arab states to work together, to harmonize their policies in the positive sense. But again, I wouldn't hold my breath for big changes and big decisions in the very short term. And finally, the issue of self-determination. It's a debatable issue whether or not self-determination is an absolute sacrosanct principle. For human rights law, it is, because it was put in the text. States did agree that the parent right is the right to self-determination, and that it finds expression in the individual rights that are detailed in the covenants. Okay? Politically speaking, if there are attempts to backtrack on the right to self-determination, does that mean that the right doesn't exist anymore? I'll give you another example of this idea. The Geneva Conventions say that for grave breaches of the Convention, any state has the right to pursue, arrest, and try anyone suspected of committing grave breaches of the Convention, war crimes, in their own national domestic courts. Now, there have been a number of cases, as you know, moved in Spain, in England, in Britain, I should say, in Brussels, in the United States as well. Some of those cases began to move and began to actually take. Pinochet is a very good cause célèbre of an example of Very soon after that, and after the attempt to try Sharon in Belgium, for example, Ariel Sharon in Belgium, states have been trying to backtrack on allowing their states to actually pursue this course of action, allowing their courts to pursue and accept this course of action. That doesn't mean that the principle of universal jurisdiction is dead. It just means politically the states are trying to find a way around it. So that would be my position, that in fact, if there have been detriments or attempts to reduce or redefine the right to self-determination as being anything less than the collective will of the people to discuss and agree together on what the form of their society is going to be. That doesn't mean that that right doesn't exist. Now, there is a problem with law, there's a problem with actually with rights, is that oftentimes, you have to balance one right against the next, right? So that, for example, if your right to self-determination could mean secession, but then international law also says sovereignty and the integrity of states, that could clash with the state's own sense of its own territorial. I mean, Iraq is facing that right now, right? It could define, a problem of clash of rights. Sometimes minority rights clash with fundamental individual human rights, for example, or with the right of the state. So some of these are complex arguments, but I don't think we necessarily would say, I would not say that, anybody has actually succeeded in eliminating or reducing the right to self-determination. There may be always debates about it. But there are debates about, now there have been a number of academics that have been debating that human rights are really not universal human rights. But that doesn't mean they stop to be just because somebody said, I don't accept it. But these are small voices. I mean, you have to consider that. I don't know if it's an adequate answer to what you asked or not. Feel free to follow up if you want.
Yes, well, you mentioned at one point this an individual right of self-determination. That is what I wanted you to
Oh, I'm sorry, I misunderstood. You're right. Okay. Yes, I can. What I meant by that was that when you look at the set of human rights, if you consider them, actually thinking of them as the individual human rights, the human rights are individual human rights. There are also collective human rights, and let's focus on those. They fundamentally, in their totality, say that I, as an individual, have a right to determine my destiny. So, I need to be able to freely express myself. I should be able to associate with whom I want to associate and create societies and communities. I should be able to assemble on the street and demonstrate if I want to. All of that. I should be able to be free from torture, from anything that coerces me into a course of action. I have the right to eat. I cannot have life with dignity and be able to decide anything for myself. I can't have enough to eat, or if I can't have access to affordable and adequate health care, or if I can't have, the right to an adequate shelter. I mean, all of these in their collectivity can express. I mean, it's an interpretation on my part, right? I'm not saying that this has entered a body of law called individual rights, self-determination. The point I was making is that if you think about the collectivity of those rights, then they really fundamentally are saying that, any one of us should be free. Free from and free for the variety of things having to do with human life. So, and it's not actually so extreme about it, but it is, if I am free and all of us are free in that same sense, in terms of enjoying our fundamental human rights, then we can much better and much more accurately be able to self-determine as a group. Because then all of us as a group are free from coercion. We've come to open agreement. We can agree in, culturally and whichever other way to say that we are a polity here, and we say that, our self-determination says we should be part of Switzerland. That's what we decided. So that's our self-determination. That is strengthened by enjoyment of individual rights. That's the
right of return of so many refugees in Africa, in Southeast Asia, and so on. But you never hear it said about the Palestinians. Well, we know why. The Palestinians themselves talk about it. The host countries talk about it. I haven't heard the UNHCR. I haven't heard the High Commission for Refugees. Definitely not the Security Council. I haven't heard the big powers speak of it. We know the reason. But who is remiss? What happened? And how can we adjust it? UNRWA is a relief and works agency. It doesn't have a mandate. And if I understand well, the High Commission for Refugees has taken its hand away from the Palestinians because UNRWA exists to take care of it. To me, this is a black hole. Am I right? And what's the way out?
Sorry. Just a leading question. Can a refugee actually, or a refugee does have the right to refer to a court of law to sue a host country, a host state, for not applying international human rights law and international humanitarian law? Sorry, my Lebanese friends, but I'm just not. This is my first question. Second question: Are there any precedents in this? A refugee, as an individual or collective group, would refer to a court of law, whether international or domestic? Thanks.
Aziza Khalidi, thanks for the presentation. My question is regarding Palestinian refugees. Political rights, people may not need permission to exercise their political rights. And I believe, I could humbly say from the experience of many Palestinian refugees here in Lebanon and elsewhere, and by just saying I am a Palestinian, it's given the sector colonialist, etc. It is a political statement. So to what extent is there a concept in the international instrument, as it is in the common law or the norms of the states, of the de facto practice of refugees? To what extent do they constitute norms? And to what extent are they recognized as concepts? And the idea of the dimension of identity, which even complicates the Palestinian refugee situation further, which is the return where? To their homeland. What defines homeland? And that's also it. So to what extent is the configuration of the Palestinian refugee situation, and I think it's quite linked to the black hole, to what extent could it be described by international law, or is it described by international law?
Yeah, it's definitely linked to the question Alan asked. And as you were saying, that I was actually just finished doing an arrow to it. Yeah, I don't think there's a legal black hole as such, actually. I think there may be a hole in the recognition or the acceptance or the willingness to really engage in the full discussion about implementation. I don't think there's a black hole of whether or not there is a right of return, whether it is there or not. The interpretation of it, and this is partially an answer to your question, as return where, return to what, exactly, can be subject to negotiation, can be subject to discussion. Generally speaking, the broad concept of the right of return means return to one's country, to one's national origin, national home, in broad terms. Now, as these things develop, the assumption being that, states are somehow, homogeneous or clear, or Palestine is Palestine, Jordan is Jordan, etc. That makes that assumption. But at the very least, this is very different, I should say, this is what I wanted to add to that. Not to confuse the right of return with the right to property, to ownership of property. That's another matter altogether. So I can own property in the country, that's not mine at all, that's not the issue. So the return to the original lands and homes refers to, which is the term I think used in the Assembly Resolution 194, no? That all those wishing to return to their original lands and homes. 194.
Households.
Sorry?
Households. Households and lands.
So it's referred to specific places like houses and houses. But generally, the right of return refers is more broad than that. It's a question of leaving one's country and returning to it, in very general terms. So the fact that the UNHCR didn't intentionally take its hand off the Palestinian refugees, they were actually not allowed by the definition of refugee in the 51 Convention. Article 1D that specifically excluded that the term refugee doesn't apply to anyone who already receives protection or assistance from other UN agencies, which is very strange. It's the only place we see it in the UN Convention. Right? So that meant automatically that, with UNRWA working on behalf of refugees, UNHCR, it actually went through a lot of problems. There were a lot of discussion, and a number of articles and research were written on what was called at that time the protection gap. That was a number of years ago. Gail Holding and the Deal Research Center in Bethlehem. There were a lot of work on what was called the protection gap, meaning that UNHCR, which provides protection and assistance to refugees, excludes the Palestinians because they are covered by UNRWA, where UNRWA works, right? And UNRWA only provides assistance. So who provides the protection? There's a protection gap. In fact, that's been changing. UNRWA has begun to take on the protection role. It had recently hired a protection officer. Well, both protection in the definition of UNHCR. And I have a problem with those definitions myself. Because even those definitions, even of UNHCR, defines protection as primarily providing assistance. You protect them from the cold, you protect them from hunger, but you don't necessarily protect them from the army. That would be another matter altogether. So that is an issue. UNHCR basically redefined its understanding in a memorandum in the early 2002 or 2001, I can't remember. It issued a clarification of what it understood, basically saying we will not work with Palestinian refugees where UNRWA works. So that means that's why they have been engaged in helping the refugees from Iraq, for example, on the border for resettlement for finding resolutions. They tried to take up the issue of Palestinian refugees in Egypt, but the Egyptian government would stop and went to the UNHCR and said, never, not on your life, do you deal with Palestinian refugees. They're our responsibility. There's about 60,000 Palestinian refugees in Egypt. So as a political position, the Egyptian government stopped it. But UNHCR was willing to take it up, wasn't that? But it was more of a division of labor between UNRWA and UNHCR. More generally speaking, in terms of okay. Very interesting question on being able to host, to sue the host states. Now, I think it would be good to actually look into and see how often that has happened. But I would certainly say that for refugees that have the legal status, but sometimes they don't. So, for example, Palestinian refugees registered in Lebanon should be able to sue, should be able to go to the courts and sue. They should be able to have legal personality to go and sue because they have a legal status. They can sue somebody who has offended them, or even sue the state for not providing this or not providing that. I think that legal provision should be there. If you remember in my talk early on, I said one of the non-derogable rights is legal personality. I should be able to go to the courts and protect myself. Any courts in the land. Right? So I would say that right should exist. It does exist. Now, whether people have used it or not, to what extent, probably needs to be looked into. I don't really have the information. I don't have it.
Sorry, for instance, I'm not allowed to work as Palestinian refugee. Can I sue the Lebanese state for not giving me permission to work because I'm not Lebanese, I'm not a foreigner, you know, that controversy.
We'll have to talk with a lawyer.
I'm a lawyer. I'm a lawyer, but
There is one way to find out.
There is one way to find out. Yeah, Rhoda?
Rula Badran from the Palestinian Human Rights Organization. Actually, in one of the our legal aid projects, we had this part, like to raise or to sue the state and specifically about the non-ID issue. And it was a very big project, and we received an approval for it. But at the end, the ambassador of the state that was providing us the money, what he did is he changed this money, and he said that no, we cannot afford as a state to provide an organization money in order to sue a state because not providing the rights. And the whole project was dimensioned. After it was like a very big one, it was dimensioned to a very, very small one. But it also made an effect in the issue of the non-identified Palestinian refugees in Lebanon. And it contributed to the process of identifying the Palestinian refugees, those who are not identified, but it took lots of time. I think that it needs a huge effort, not only from the civil society, but also from individuals who will agree to put on their matters, for example, the ownership. And there is discussions about this, Nizar. If you find out a group of Palestinian refugees who agree to go with you to the court, because we, for example, as Palestinian Human Rights Organization, NGOs does not have the right to sue before individuals. So there should be individuals who raise or who file this law cases before the courts, and then they have a lawyer who will follow up. So also this, but it needs lots of efforts, and no one guarantees that the general security will not be following you, or threats will not be, you will not be receiving threats, or even you will not be killed.
No, I'm talking legally speaking.
No, but legally, I think that it's very important, and it should take place at a certain stage.
Thank you. Thank you, Rula. I think this is actually a very good example of what I was trying to say at the end of my talk, which is that it's really, in large part, up to civil society to push the envelopes, to say, okay, let's try. Does it work? Let's see if we can do it. I don't blame the ambassador, puts in hot water if he does that. But in fact, if money can be raised at the local level, even passing the hat, just to test an idea as important as it is, I think would be very useful.
I think we have time for one last round of questions. Is there anybody in the back that I've not seen?
Just about the issue of de facto activity, the issue of my query about what does the international law talk about, how does it describe de facto exercise of political rights? Is there that?
Generally, when law talks about political rights, it talks about fairly specific things. It doesn't talk generally about engaging in political discussion, for example. It talks specifically, for example, about the right to form political parties, the right to elect or to run for election. These are all, a set of very specific political activities in the context of a state that are called political rights. The fact that, 20 people get together and declare themselves party can be illegal in some countries. They can get together and declare a discussion group on politics, and that may not be illegal. It all depends on the very specific activity and the very specific context. Certainly, the Palestinian movement, has actually been a fundamental part of Arab politics since the mid '60s. And they've created and brought back governments and done quite a bit without anybody actually giving them the right for political action, certainly. But that doesn't mean necessarily, it's not the same thing. The exercise of political rights, as described and thought about in law, is more specific about that. certainly, I mean, the other way to push the envelope, of course, is to always just do what you want to do and see if anybody stops you.
Committee for the Employment of Palestinian Refugees. Been some talk about employment of Palestinians in Lebanon. Of course, we all know in the chaotic situation prevailing in Lebanon, many Palestinians are actually working. What we should be talking about is formalizing the employment of Palestinian refugees, because the conditions they're working under now leads to exploitation, long hours, working as engineers but not being labeled as engineers, working as a nurse but not being registered on the hospital books. So in actual fact, many Palestinians are employed, but they have no security in their employment. They're not protected by any laws. They may work many years and finally end up with no pension, no rights, no social security. So what we should be talking about really is formalizing the employment of Palestinian refugees, which would involve new laws or the revision of current laws so that Palestinians can work in a legal way, legal quote unquote.
That's correct, Ambassador Shamir. But I would add to that you know, in addition to the idea of formalizing rather than allowing it to continue in the informal economy, part of the idea of formalizing has to be the question that they actually should have the right to work, certainly after 60 years. They should have the right to work, and the right to work and to be registered in their professions and to receive equal pay for equal work along with their Lebanese brothers and sisters also includes the right to pay taxes and to participate in the economy of Lebanon in every other way. So it's also a benefit to the state. So the idea there is to combine the economic policy idea of formalizing informal work with the legal obligation idea of rights-based approach to provision of work opportunities. And that would then accrue to the benefit of both the Palestinian refugees working and paying taxes and participating in social insurance and everything else, and of course the state that has the benefit of having an accurate assessment of its own economic outlook, as well as its tax income and everything else that follows from that. So thank you. Yeah.
Thank you. My name is Noor. I work at the Arab Human Rights Fund. I have two questions to ask you. One is, today, have there been political proposals to implement the right to return? And the other question, do you think that the right to return will disappear in 2 or 3 generations in the future for Palestinians?
Okay, and I think this is the there have been, of course, there have been a number of proposals, mostly from non-Palestinian people. Palestinians have actually engaged in discussions about the right of return. And actually, I shouldn't say that. There are also proposals from Palestinians on implementing the right of return. There's a number of them, some that have proposed, in fact, a partial or limited return to 1948 Palestine, what is now Israel. Most proposals talk about the right of return to the Palestinian state, but not necessarily to the original lands and homes. Some have proposed, in fact, a full right of return with equal citizenship with Israeli Jews, such as AUB Center, for example, who's actually made calculations and arguments about where they could go and how they can be housed and where they can live, etc. The actual Palestinian-Israeli negotiations talked about a recognition of the right of return, but only partial implementation. And most recently I also heard that one of the proposals that were bandied about was that approximately 70 to 100,000 Palestinians would be allowed to return to Palestine 1948, what is now Israel, but with two caveats. One is they have to be over a certain age. Secondly, the other one, which I wasn't aware of, which came as a surprise to me only very recently actually, is that there have been proposals that they could do so, but they could come as permanent residents, not as citizens of Israel, in that sense, which I wasn't aware of before. So the idea there is to, to have people come and be able to reside in what, used to be in the area of origin, etc., but not actually be citizens of the state, not having political rights at all in the Jewish state. So there have been a number of different discussions and proposals, and there's even this one, Zahra, I can't remember her name, some years ago that proposed actually how the Palestinians would be, some would be allowed to go back to Gaza, and the rest would be integrated and with specific numbers had been calculated on the basis of economic capacity to absorb in Lebanon and Syria. And, there have been even rumors that right of return to Iraq, for example.
Okay, thank you.
I don't think there's anything on the table right now at all.
Do you think the right to return will disappear in the future?
No. And on this optimistic note, I'd like to thank very much Mr. Fateh Azzam for this lecture. Before I also like to thank Zeki Boulos and Tana Mahfoud for their work in setting up and arranging this talk. So thank you to all. Thank you for coming. Thank you very much.